Hello and welcome everyone to today's episode of Legal Talkies with Abhijit. I'm your host Abhijit, and today I wish to talk about an important form of ADR, or in other words, alternate dispute resolution, which is mediation. So, as you all know, mediation is something that was always present in our Indian system of dispute resolution since the ancient time, and a reference to it can be made in the form of the panchayati form of justice, wherein in villages the panchayats used to dispense justice through mediation, or as in Hindi we would call it madhyasthata. Mediation essentially consists of a structured process where there's a neutral mediator who mediates the dispute or legal dispute between the parties. Now, recently there's been a lot of shift and push towards mediation, which has been in the form of passing of the Mediation Act in 2023. So the Mediation Act of 2023 has given a lot of impetus or push towards mediation in India, a structured mediation process. Now, there are a few key points that I wish to speak about when we discuss mediation that we must keep in mind. So, we need to understand that mediation uh, is basically limited to civil or commercial disputes, and there's an indicative list of matters which is provided under the Mediation Act in which mediation cannot be held. For instance, land acquisition matters or heinous offenses, criminal offenses. For these offenses, such as the criminal offenses, the mediation cannot be conducted, obviously. So now we need to understand one very important facet of mediation, which is that in our everyday dealings with each other, we often enter into agreements or contracts. Now, it is very important for us to add a mediation agreement clause in these agreements if we want our disputes, in case of dispute in our agreement with the other party, to be governed by the Mediation Act and for it to be solved through mediation. Now, the issue is that there is another form. So, in case in your contract you fail to add a mediation clause, though it is preferable for parties through their own consent, through their own wisdom to add this mediation agreement clause, which is a standard few liner clause. But in case that is not added, still the parties can opt for mediation when their case goes to court. That is, when the case goes to court, both the parties can give their consent for mediation. That is the dispute to be resolved through mediation. But to avoid a situation where parties wish to go to court, they can also include a mediation clause in their agreement, like arbitration clause. Similarly, a mediation clause can be inserted in the agreement, and the mediator can be appointed in accordance with such a clause. Now, it is important to note a very important facet to be noted here is that the mediation settlement agreement, that is the mediation settlement, once it is reached, will have the same force as that of a decree under the Civil Procedure Code. So that is to say that the mediation settlement will have the force of law or force of a decree as if an order passed by the court, and it can be enforced in the same manner as provided under the Civil Procedure Code. Now, a few more essential points to keep in mind is that this is not an endless process. For instance, if a mediation, by virtue of a mediation agreement or a court appointed mandated mediation is started, then there is a time period, a definite time period which is provided of 120 days, which can be extended by a further maximum period of 60 days. So that is to say, mediation as a process needs to be finished or completed in a period of 180 days or 6 months in total. So that is a good aspect. The other aspect is the issue of registration of these mediation settlements, subject to privacy, of course. If the parties so wish, they can get the mediation settlements registered once it is reached and signed by them. Uh, then the whole issue of challenge to a mediation settlement is also provided under the Mediation Act. It says again to streamline the whole process of challenge to the mediation agreement. A limitation period of 90 days, initial time period of 90 days is provided from the date on which the mediation agreement is entered into. Further, a subsequent, in case of a delay, further 90-day period is provided. So in total, 90 plus 90, that is 180 days is the time period or 6 months from the date of this mediation agreement that the mediation settlement agreement can be challenged. Now, a very progressive feature of this Mediation Act, which I must mention now, is with respect to online mediations, which is provided under Section 30 of the Mediation Act 2023. Now, what it really speaks about is that if the parties consent, the mediation can be conducted through VC or through online sessions as well. Now, this is subject to party agreement by, I mean, consent by both the parties. If that happens, then the mediation can also occur through online mode. So that is a very progressive step which has taken place now. With this, we draw to the close of today's informative session on the Mediation Act as a form of alternate dispute resolution. I hope you found it useful. Please share your comments and inputs, and do like, share, and subscribe the video. Thank you for your time.